All right. Good afternoon, everyone. Welcome and thank you for being here today. Tonight's webinar is entitled When Counseling Isn't Enough, What Stay-at-Home and Financially Dependent Spouses Need to Know Before You Get Divorced. So, as I stated before, come in, get comfortable. If you are a spouse who's stepped back from your career, if you've been a financially dependent spouse, if you have a partner who's managed most or all of the money, and if you just don't talk about your finances with your partner as much as you would like to, this conversation is for you. So, I'm going to talk a little bit about myself just so you know who I am and what my firm has to offer. So, my name is Attorney Sharice Williams, and I am the principal and owner of the law office of Sharice L. Williams. I'm licensed in Maryland and DC. I do collaborative process in regards to divorce, prenups, postnups. I also do litigated divorce. I would like to do settlement negotiations, child support, custody cases. So, under the umbrella of family law, you can find me. And I also do power of attorney as well as wills. So before we begin, I just want to go over some housekeeping matters. So let's just start with the fact that this webinar will be recorded. And so there's a chat feature in Zoom that if you want to discuss and have conversations in the chat, feel free to do that. If you have questions, you definitely can utilize the chat for that. We're going to use the format where I speak majority of the webinar, and then at the end, I'm certainly going to leave open opportunities for those questions and answers. So sit back and be patient. Most importantly, I want to make sure that everyone knows that this conversation is for educational and informational purposes only. It's not legal advice. It doesn't create an attorney-client relationship between us. But certainly, if you want to learn more about what our firm has and if you need some case-specific things talked about, then yes, you can contact my office. My number is at the bottom of this screen. So definitely feel free to do that. We welcome any contact so we can try to help you with your personal matter. All right. So with that being said, let's get started with why we're here. Why this conversation matters in the first place. So let's talk about divorce. Divorce, this is not a conversation that is about encouraging divorce. It's a presentation about information and being prepared. You want to make some informed decisions. So, looking at how to seek out education about legal and your financial position before you make that life changing decision that can come with that divorce. So, divorce decisions rarely happen overnight. I know this from a lot of experience. Most people struggle for months with this decision, sometimes even years. And so you can often feel a sense of fear. You may have you may have some financial uncertainty that's going through your mind. You may struggle with whether or not this is the right thing that you want to do. So my goal today here is to give you clarity and not make and try to make some of that fear go away. Because when you understand your rights, you can expand your capacity to understand what options are next for you. Okay. So if you have questions like, how will I support myself? What happens to potentially my house? Can I even afford a lawyer? Will I lose everything? Those are the things that people that may feel vulnerable and have financial understanding uncertainty think about. But here's the truth. Information, like I said before, will create options, and we're going to work on learning how to prepare so that you don't feel like you have to shrink and not understand what next steps work for you. And especially if you're in marriage counseling, but you feel like now where you're getting to the end where that's not going to work out. So let's talk about that. When counseling isn't solving the problems in your marriage. Now, counseling is very valuable. I believe in individual and or couples counseling. If you have things that you need to work on and you have somebody independent who can give you techniques to cope and handle manage any problems or issues that you feel like are in your life, trauma even. But couples counseling, unfortunately, does not require you to disclose financial information. with your spouse, it does not create enforceable agreements. So a lot of times, if you go to couples counseling, you may not even think that there's a power imbalance, or that if you know in your marriage that you're not the one who shares your financial information, or your husband or wife is the one who the breadwinner, but they don't actually tell you how much they make, and you guys kind of have separate bank accounts, you might have a joint. Those are things that you may not even bring up in counseling because you think everything's okay with it. You may not actually see it as a problem, and I'm not here to tell you that it's a problem. However, in a divorce, information is what you need to be able to decide on your property and who gets what in the equitable division. So if you don't know in the marriage, when you get to the point of divorce, you may need that legal clarity because someone may try to withhold that information from you. And it's hard to make decisions when you don't have the information. So if one spouse handles all the finances, that's where that imbalance comes in. And so the legal clarity may be needed and legal advice may be needed. Doesn't mean that you need to file tomorrow. It just means you need to understand your position. So now we're going to talk about the common financial imbalance things that I see. Again, number one is when one spouse often manages the finances. Another one is just because you have access to that information in that account doesn't mean that there's equal ownership. It doesn't mean that that person owns that. And so a lot of people think, oh, my name's on this account. My spouse's name's not on that account, so they'll think they don't have a right to it. But that's not actually how you make a determination of marital property. And that goes for the house. There's so many couples where one person may not have been on the mortgage, but they may be on the title, or they may not be on the mortgage or the title. And that decision was made during the purchase, but it doesn't mean the other person has no equitable share or ownership in that home. So that's why it's very important that we use the right language. So looking at the fact that you don't have access to the login rights to accounts, you may not have seen a bank statement. It doesn't mean that you are eliminated from having legal rights to that. So dependence on your spouse does not mean that you're powerless. So having that awareness is the first step. Okay. So next we're going to talk about I can't believe how can I afford a lawyer? Since Maryland is an equitable distribution state, I want to just say that that's important. Why naming names on an account doesn't necessarily make a determination as to what the court will do. And so it's important, even with retirement accounts, those are included in this business, real estate, investments, all those things that are accumulated during the marriage. So let's talk about the ability, not the if you can't afford a lawyer. Your ability to pay is not just cash based. So, me mentioning all those things that I just mentioned, investments, real estate, retirement, and just, yes, cash. That's all part of the equitable distribution process, as well as your debt, because a lot of people have credit card debt. So, the courts are going to look at all of those things. So, your ability to pay, the courts will consider those things and they can award temporary alimony or support. So at the beginning of the case, if you need to get a lawyer, a court could then just make a determination that they will get the assets from your spouse if they're the ones who have like physical control over it, and you can ask for them to assist in your legal fees. The court also requires financial disclosures, so you may not know what your spouse makes now, but there is a way to find out what your spouse has so that that can give you that information so you know what to ask for. So early advice in a case is very powerful when you're thinking about a divorce. And that's why having possibly an early consultation can give you information and a leg up. So now we're going to talk about how a lawyer can help you. So again, knowing about your assets and accounts is one way. You also can talk about the property, real estate, and living arrangements. Those things are important. So your lawyer can give you information about who should move and strategically how that looks. You want to get help on your employment or lack thereof. If you're the dependent spouse, you may have given up your career. but there's things that need to be discussed as far as, are you going to be able to rehabilitated and get back out into the workforce? Is that something that's possible? And if so, what will that look like? Because you may be asking for alimony, but for how long? And what is your expectancy? If you have a disability, you may need support for a very long time. And if you have a super wealthy spouse, some people get support for even longer periods of time. So when we're looking at that, it is super important to know what information you have. So you need to be honest with whatever lawyer you have, even if you have incomplete information, because that's something, there's methods to get information when you need it. And you can see that as the case proceeds. So the next thing we're going to talk about is the authority that comes with the court. So looking at court authority, if you are found, if you one of the processes with the court, and just talking about utilizing the court for litigation, they do have that authority to issue those temporary orders for not only alimony, which another word is support for you, which can be legal fees or just your everyday living, or child support. If you have kids, that's also going to be something that you may need temporarily prior to getting to the end of the case, where the court will make final decisions about custody, child support, alimony. And then also those contributions towards the legal fees, they have a right to decide on that. Now, all of these things are based on need and ability to pay and many other factors. So they'll ask, that's something your lawyer can argue about, contributions towards those legal fees, the court can award them. So that sometime can be done up front. So those who are worried if they can pay for their legal fees, that is one method utilized often by dependent spouses, is utilizing temporary legal fees and alimony. Okay. And with those mandatory disclosures, which are signed under oath, your spouse is supposed to at least give an indication as to what their income is. So you may never have known what that income is, but in these cases, that information has to be disclosed. So that's something you'll finally have some information that will be at your disposal. So the court has discretion. It's subjective. Sometimes it doesn't go your way, but oftentimes, if there's a big disparity, that is the way that you're going to accomplish, surviving up until your final divorce proceeding. So now we're going to talk about what filing for divorce triggers. Okay. So looking at utilizing the court, we're going to say that the court filings trigger the court having jurisdiction over your case. And jurisdiction means that they have the authority, the subject matter authority to hear your case. So divorces, depending on which county you live in and which state. I practice in Maryland and DC. Obviously, there's multiple counties in Maryland. So depending on where one spouse lives or works, you can file in that jurisdiction, so that the court should have jurisdiction over the divorce. Circuit court, not the district court in Maryland. There's deadlines that have to be met. So in the court process, there's a lot of things that you need to follow along the way. And so there's going to be things that your lawyer knows how to do. So it's helpful to have a lawyer. If you don't, the court can give you guidance, but they're not going to show you how to do it. So pro se or people who represent themselves sometimes have a disadvantage because they miss deadlines, they miss documents, and the court has expectations that you know how to do it if you're not represented. So don't go in and use the "I'm representing myself" excuse. It only will go so far. So it is super important to reach out to legal counsel, legal advice, or representation, so that you don't mess up or have consequences because you inadvertently missed deadlines or didn't file something in time or file something at all that is super important in your case. Know that the court is there's when you file a divorce, it is technically a public record that can be pulled in the future. There are some parts of it, like social security numbers and that are private, but it is overall your record is public. And this keeps the integrity of the court, and there's a whole thing about that. And so are your court hearings. So unless there's like child abuse or significant abuse, say in some other ways, I won't name it just because it's YouTube, but there are things that can be hidden in private. But overall, these are public hearings. So of course, there increases the cost of your case if you're in court, because if you do have a lawyer, legal fees. And so it's going to trigger the cost, and you'll be billed by the hour or some mechanism as to what your lawyer has. So those are the things that are triggered when you do the court process. So now we're going to talk about what process and what choice you have in making a decision to file. So when you make a decision to before you file, you need to decide how you want to go about it. So some people will go to court right away and file, but when you do that, you reduce personal control. So looking at just filing where you don't have an agreement with your spouse and you're just going through the court, that sets up a litigation and a litigation track case. And so again, you're going to have those increased costs and expenses and stress. You also have timing within when it comes to that that can be impacted because if you file, you may feel like you're the first one out, but it also puts up defenses. So strategy on how you go about your divorce is important. So don't think that just utilizing that method is the best and the only method. So now, in looking at that, you also have the option to choose other methods for litigation. For example, you can do mediation, you can do collaborative divorce. You may have other options like settlement conferences or settlement attorney with an attorney try to settle with the other party. So using the right process can help you because some of them are more transparent. The power dynamics, safety, a lot of different things can come into play. So your process that you use to go through the system it matters. So doing that, thinking about it and being informed is super important. So let's talk now about the one of the things that I mentioned out of those processes, which is called collaborative divorce. That's an option. It's a process. This process is an alternative dispute resolution process that is utilized. However, when you think about collaborative, it's different from traditional divorce because you're making a commitment to settle the case. This is client driven and lawyer led. And sometimes you're going to have a team of people. So you may have a mental health specialist. So sometimes the mental health specialists feel like they're at the lead because they kind of coordinate and they can help run the meetings. But each person will have a collaborative lawyer that will help them navigate and advocate for them. But we're working together. We're not working as opposing counsel, which is what is done in traditional litigation. We do believe in this process so much, so you do need to sign something committed to settlement as your goal. And you need to have transparency in this process. So full financial disclosures required in this process, and they're structured meetings where you're going to have a goal and you're going to meet those goals. You have meaningful discussions that when it comes to your finances, when it comes to what you want to do with your kids and just other areas that help your marriage dissolve essentially, and then even discussing how you're going to live post divorce if you're co-parenting. So this process is private. It's resolution outside of court, so that's very helpful to a lot of people. You don't have to submit all of your personal documents into the courtroom or testify where your information will be disclosed to the public. So collaborative is appropriate for a lot of couples who are willing to hire attorneys. This is not a thing where one person can hire and the other can't. But there are some situations where it isn't appropriate. So we can talk about that. So looking at some of the times when collaborative may or may not be appropriate, let's talk about if there are people who don't want to be transparent. So there are people who don't want to turn over documents, they hide documents, they will dissipate assets, which means they're going to spend money really fast so that the other party won't have access to it. So sometimes they may not be eligible because they're not going to be transparent and they're not going to turn over what they need to turn over so people can make an informed decision in the divorce process. You can also look at if there is a severe power imbalance due to physical abuse, financial abuse, emotional abuse. All of those things we would have to assess as the professionals and make a determination that this party would not be an eligible candidate for this process. So we want to make sure everyone's voice is heard and that everyone feels comfortable speaking. So that's what the collaborative is known for. So we do have to do some legal screening. And I will say no one process is superior, but I do strongly advocate heavily for collaborative because I think when it comes to family law, you are better off making decisions as a family and not letting the court make decisions because they don't know you, and testimony at a trial won't let them get to know you. So it's not the best way to divide assets. It's certainly not the best way for you to make custody decisions about your children. So for me, this is a better process for the children and for you as an individual. But again, not everyone is going to be eligible. So let's talk about what you can do before you file. Looking at the purpose of this discussion is you want to learn your rights. So if you're in counseling, you're in a marriage and you're in counseling and things may be going in one direction, but you're not sure, or even if they're going good, but you still want to know your rights in the event something happens. It is super important. It's okay to talk to a lawyer. No lawyer is going to force you to sign on the dotted line after a conversation, but knowing what you need to protect, what you information you need to know, and that's something that is helpful to you so that if and when you're ready to make another decision, you can. Um, Ask informed questions. So once you're in with your lawyer, you then can have the ability, questions may come up and you'll have more information that may raise more questions. So you can consider those process options that I discussed, whether it's mediation, litigation, collaborative divorce, just settlement talks. You can do all those. Some people get post-nuptial agreements when they're already married and they're not ready to divorce, but they want to protect themselves. These are all options. A postnuptial is a contract that can decide on how you would separate your assets. So people can utilize that, and that can be a method. So you definitely can come to a lawyer and have those conversations and still stay married. Okay, so that's why these are things you can do before you file. So planning stuff before reacting is always a wonderful way to handle your case. So having those conversations and creating a strategy is something that I advocate strongly for. So I'm hoping that you got a lot of useful information. I know time flies so quickly. We're now at the part of the presentation where there are questions, and I do see, I think I had a few questions that were pre-submitted, so I don't see any in the chat right now, so I guess I'll start with those pre-submitted questions. All right. Um, so one of the questions that was pre-submitted says, what if my spouse starts moving money or changing accounts once they suspect that I'm getting a divorce? So if you know that that's happening, you have the authority to issue orders preventing dissipation of marital assets. So this is if someone used the litigation route. Then you can ask the court to prevent people from doing that. And so that is a method that you can utilize to try to prevent what you think will be a complete wipeout of an account or retirement or something like that. So if so, that's something that is important to think about. It says, another question I see here is says, what if I'm afraid that once I start this process, there's no turning back? So I always say gathering information does not start a legal process. Consulting does not lock you into a divorce. Even filing doesn't mean that the marriage must end immediately. You can pause sometime. It's hard, settle, or resolve in many different ways. So you need to learn your options and not close door. But sitting back and waiting sometime also doesn't enhance your life. So don't limit yourself, just stay informed. And when talking about thinking about this preparation, also thinking about learning more about collaborative, because you may, if you're a couple who did counseling, then you may be great for collaborative because thinking about both of you getting an attorney and you can knowing that you're the spouse who may be dependent on the other spouse, you'll have the ability to have the income, which is the same pot. So that same pot of income that has been spending the money on the bills in the household, you're able to possibly use that for your lawyer, and then your spouse can use it for their lawyer. And so when you're dividing up assets, it feels fair for everybody involved, and you won't necessarily be scrambling trying to figure out how you can pay for your lawyer. So if you have a spouse that's already willing to talk to you, and you may be a good position to be able to have that conversation so that you can sit down, have the team approach and help. And definitely if you have kids, because your kids will see that you guys are working together. And that's the one of the better messages to send children, because they're going to feel their own emotions when you're going through a divorce. So having that, and you don't have to be a perfect couple, you can still not be on great terms. That's also what the collaborative is for, to enhance communication, talk about the hurt. We're not your, therapist, but we have conflict resolution skills. So that's how we utilize those heavily in that process. So that's what makes it a process where people are heard, and then it makes it better post divorce. So you have some type of relationship outside of just being bitter exes. So let's see what other questions I see here. It's a uh the first, it says, what if everything is in my spouse's name? So that is a question that I did mention earlier before. So if it's in your spouse's name, we're going to look at when did that piece of property get acquired. And if it was during the marriage, it doesn't really matter whose name it's under. So that is something that will be marital property. So that is not the determining factor. Now, if it was inherited by that spouse, a house, a home, if their parent passed away, then that's different. And if they acquired it before the marriage and they keep it as separate property during the marriage, and there's very specific ways that I'm not going to get into here that they can do that, then they can then claim it as separate property. But otherwise, something that starts off as separate property, depending on how it's used in the marriage, can become part marital property. So that's something that you also can make a determination of during the marriage, and a lawyer can talk to you about the meaning of that. So more reason why having informed, making, having conversations about this is important. So again, all of these things can benefit you in the end. If you're a spouse that's feeling like, I don't have the means, I feel trapped in the marriage, I don't know how I'm going to get out, this lesson and this webinar was meant to give you some more strength to step out and get information, find out what is right for you, what your next step is. If you want to stay married and continue in therapy, that's also your right. So that's also one of the options that you can choose. But it is important to know what's next, what's out there, what the law really says, instead of listening to your neighbor, your brother, your sister. Every situation is different. So you want to know what's right for you and make that decision yourself. So I thank everyone for coming here today. I really enjoy doing these webinars. I love educating the public. There's different topics that come up over the years. So I decided to do a series where I can help people with information and education, of course. And some people just, it's also entertainment for some. But with that being said, these are all my social media handles: 50 Shades of Law, and YouTube, Instagram, Facebook. I ask that you follow, share. You may know someone that needs to hear this. You may know someone that's struggling. So that's what these webinars are for. So share the video, share the link. Catch us next month. We're going to be doing another webinar. And I thank you for taking your time out to listen to me. And call us if you need us for individual advice. My number is 240-499-8569. Thank you very much.